Hey everyone, I'm Brian T. Bradley. I'm an asset protection attorney and the senior managing partner of Bradley Legal Corp and an of counsel attorney at Laudmill and Laudmill, as well as a lead attorney and advisory board member at the Asset Protection Council. And you may have heard me talking or lecturing on various continuing legal education platforms or investment shows like Bigger Pockets and others. As we're going through this journey of asset protection, we realize we have different tools. We need to remember the main goal of asset protection is to create a legal barrier one way or the other between our clients and the creditors suing them. And so we need to understand the different tools we have and the principles, as well as when to use them or not. Our two biggest tools that we have are exemption planning and asset protection planning using LLCs, limited partnerships, and asset protection trust. What exemption planning refers to is the type of protection we get from state and federal laws that exempts assets from creditors. The creditor is valid, the claim is valid, the judgment is valid, but this asset is just not something that they can collect on. A few examples of exemptions are homestead exemptions, like in Florida, where they are 100% exempt. This is the best standard. That's as high as you're going to get, 100% exemption. Now we have, California surprisingly joining the party on exemptions and homesteading and increased the amount to potentially $600,000 for a homestead protection. So even though exemptions are generally exercised through bankruptcy, as a practical matter, creditors will typically discount any homestead under the exemption amount. So bankruptcy is not always required to get the benefit. So this is surprisingly pretty solid thing that California did. The problem, with this in California is that most of the properties in California are well over the $600,000 price. And so if you own your home outright, and let's say it's $1 million property, and you get that max $600,000 exemption amount, you still have hundreds of thousands of dollars in exposed equity just in your primary home. So now what? Other examples of exemption status assets are ERISA 401k plans, like your retirement 401k plans, which are federally protected and exempt. IRA plans, your Roth IRAs and your IRAs, which are state protected. So they're going to vary from state to state. The same with life insurance and annuities. They're going to vary, and some assets through bankruptcy. The way most exemptions are used, like I said, is through bankruptcy. So it has some limitations to it. And we really need to think about, if you want and need to declare bankruptcy, like this is going to be a big determining factor. And if you have not, as an attorney, if you have not taken a CLE course on bankruptcy, I recommend that you do that and at least get a little foundation in what happens in bankruptcy. And I'm going to do another video later on down the line on bankruptcy versus asset protection. So stay tuned for that. Now, asset protection planning is different. It does not rely on state and federal statutes to say, hey, these are exempt assets. It just uses legal tools to limit the access of the asset to a creditor. And these are spendthrift provisions, spendthrift trusts, charging order protection entities like LLCs and limited partnerships, or locked up and unreachable assets. So while the asset is locked up, let's say by debt, so sometimes debt can be a good thing, there's no access to the cash. And that's what the creditor is after. So now you're going to probably be asking, okay, so which one is better, exemption planning or asset protection planning? We may be looking at the exemption status and think that looks a lot better. So why not just do exemption planning all the time? But the drawback with exemption planning is that it can't just be arbitrarily expanded. You can't just say, okay, great, your state has all these exemptions. Let's just move all of your assets into them and change them to an exempt status. And it's really hard to convert 100% of a client's assets into an exempt status. So then you need additional planning. So the best practice procedure on this would be maximize exemption planning first, and then move on to asset protection planning and combine domestic and offshore planning, which we're learning about later on and breaking down the different types of trust for that. So thanks for listening. I hope that you found this helpful, and you can always reach me at Brian BRIAN at btblegal.com, or you can jump on my website, www.btblegal.com, and feel free to ask me any questions and, contact me for a free consultation. And again, I hope you enjoyed this short video on exemption planning versus asset protection planning, and have a great day. Bye.